Purdue law offices, but I wasn't at Purdue when it started. That was my father, John Purdue, and I had the privilege of working with him for 20-some years. He was also a patent attorney and chemical patent attorney. So, yeah, we don't have much in the way of chemical knowledge at the firm anymore. He died in '09, and I became Purdue Law Offices. I started out as a patent attorney, and I was admitted to the Patent and Trademark Office in 1984. And I guess my position has evolved, which is kind of popular these days. I am leaning heavily towards trademarks, and I think as we go through the materials, you'll get a sense of why I feel that way. I like to fish. I don't ride a bicycle very much anymore. And we're going to talk about intellectual property around the world. How many? 216 countries? Is that close? Buckle up. We got a lot of ground to cover. Intangible and tangible assets of businesses. I don't have a hard report on this, but many people have opined that intangible business assets are worth more today than tangible business assets. Intellectual property is intangible. We can't hold it in our hands. Well, we can hold a patent in our hands, but behind the patent and behind other documents evidencing intellectual property is the right to exclude others from doing certain things. Intellectual property is about putting a fence around things to keep people out. You all know about intellectual property. International intellectual property is tough to manage. You have to understand what intellectual property your business has, and you have to have a crystal ball. You have to be able to predict what you're going to be doing in a year from now or 5 years from now to lay the groundwork to have the protection that you should have. IP is an underutilized and too often unmanaged asset. And I think Andrew Watson is correct. And he must be British because underutilized has an S instead of a Z. Intellectual property flavors, and I think you all have a sense of the various kinds of intellectual property. Patents cover inventions. That can be a bicycle wheel. Did you hear the one about the guy that walked into a patent attorney's office and said, "Can you help me get a patent on my invention?" The patent attorney said, "I don't know, what is it?" And the inventor looked him in the eye and he said, "It's a wheel." Well, that happened to me, and his name was Rolf Dietrich, and we met in 1991. And his was a special kind of wheel. It was a bicycle wheel. It was very lightweight. It had fewer spokes than conventional wheels, and yet it was more stable. And actually, he received several patents. The cover of one of his patents is in the materials on page 5. So I do know a guy that reinvented the wheel. He was an independent inventor. He didn't have a business. He was actually an engineer working out of Detroit and a amateur bicyclist. It took a long time to patent the wheel. Other kinds of inventions that can be patented would be methods for producing things, machines. I think we know pharmaceuticals are patented because of the high prices we pay until they come off patent and are available in generic form. So pharmaceuticals and chemicals, these are all things that can be patented. So you have the subject matter requirement, and then to be patentable, an invention has to be new, has to be somehow different from what came before, and if it is different, the differences have to be such that the invention would not have been obvious to somebody skilled in the art looking at what came before. And obvious is the loaded term in patent law, and that's what keeps patent attorneys awake and makes their hair turn white and fall out. But we've issued over 8 million patents in the last 100 or so years, and the rate of issue is increasing dramatically. It did increase dramatically over the last 2 decades, and it's somewhat tapered off. We're up to a backlog in the United States Patent and Trademark Office of 950,000 applications awaiting action by the office. And part of my problem with our U.S. patent system involves the delay in getting a patent. 5 years is typical, sometimes longer, and a lot of inventions don't even have that kind of useful life. Patents are ridiculously expensive to get in the U.S., 5 figures. 10 to 15,000 is typical. Once the patent issues, you have to pay maintenance fees to keep it in force, and on March 19th this year, they raised those maintenance fees by 50% because they need money to hire new examiners to examine the backlog of patent applications. There are other inventions that can be protected with a patent in the United States. One of them is the ornamental design of a product. So this could be the shape of a bottle. This is luxury vodka distilled and bottled in Russia, and I'm sorry if you got here late and didn't get to have a screwdriver with the rest of us. But that design is protected by a patent that's on page 6 of the materials. The term of a patent on an invention like the wheel is 20 years from the day you file your patent application. As I say, there's 3 maintenance fees payable. The term of a design patent is 14 years, and you skate on maintenance fees. Cost of getting a design patent is more like $3,000 to $5,000. Design could be for a package, it could be for page 7 of the materials. We have a battery shown in dotted lines, and the design that's protected here is just this side panel with what looks like cooling fins, but they're just decoration, and they are something that visually sets this product apart. And the design patent, of course, gives the owner the right to stop other people. People come to me wanting to get a patent, and they say, I want to keep other people from copying my invention. And that's how it works. The patent gives you the right to stop other people. It doesn't prevent other people from using the invention. That's up to you if someone is infringing. And this is another problem I have with our U.S. patent system, and I guess it's U.S. litigation. The cost of enforcing a patent today is astronomical if you take it through to a decision in a federal district court. Of course, 95+% of lawsuits that are filed don't go to a trial. But if you do, in a patent matter, that you hope to recover up to $1 million in damages, the average cost is $965,000. I don't think that's very good for the patent owners. Another flavor of intellectual property is trademarks. And these are the identifiers. Oh, good. These are, yeah, the slides don't include the visual aids here, so we're still on this slide. Trademarks identify the source of a product. A trademark is your identity in the marketplace. Trademarks are very important. Trademarks are less expensive to register. Trademarks are less expensive to enforce in case of infringement. Mississippi barbecue sauce, real American barbecue. It's the whole label that's shown in page 8 here. And trademarks only exist in connection with a product or a service. And by that I mean, if you register your trademark, your rights are tied to whatever product you register it for. So if I register Mississippi for barbecue sauce, I can't stop other people from using Mississippi in connection with plumbing supplies. My right is tied to the product that I'm using that mark on. Page 9 of the materials, we see the U.S. trademark registration certificate for Rolf. And sure enough, Wheelboy came in shortly before he made a deal with Trek Bicycle Company, and he says, I'd like to register my name for wheels. I said, which one? His name's Rolf Dietrich. And I was kind of sad when he said Rolf, because Rolf doesn't sound good, kind of like, I don't know. Ralph, that's a good name. Rolf. I think college students have a unfortunate meaning for Rolf. But we did register that, and he did make a deal with Trek that required them to use Rolf on the wheels that they made and sold. And they had a 5-year deal. And after 5 years, the whole project was more successful than either one of them imagined. So it came time to re-up the contract, and Trek said, you've made more money than you ever could have hoped. And so we should pay you a smaller royalty now. And he told them the same thing except higher royalty, and they got a divorce. Rolf got his patents, and Rolf got his trademark. But the basic patents on his new wheel that he came to me with in 1991 have expired. The trademark is still used in connection with bicycle wheels. Back in '95, when he made the deal with Trek, Rolf had no value as a trademark for bicycle wheels. It was a word. It was put on bicycle wheels, and it took a long time, but a significant value was built up in that name. It was put on a high-tech wheel that was very light. People liked it. People talked about it. Trek advertised it, and so over time it became a trademark, and it became recognized as indicating the source of this particular kind of wheel. And it also came to represent a high-quality wheel. And of course, if you put a crappy product out with your trademark on it, you're not going to build up value. So the value of the mark is directly proportional to how good your product or service is. Another flavor of intellectual property is copyrights. And copyrights are the least expensive. Protecting a copyright is the least expensive venture. Copyright in the United States, you can fill out a form online. pay a fee of $35 and upload your copyrighted material, be it a label on a product, which is on page 11, but you can't see 11 because it's in the blue part of the battery. So kinetic, trademark for batteries. The label includes some graphic design there, and the owner or the maker and seller of these kinetic batteries doesn't want somebody else to make a look-alike battery. And that did happen. And by registering the claim to copyright, you've got a huge club to use against somebody that infringes your copyright. You may recall some of the music copyright infringement cases involving the downloading of music, and the Recording Industry Association of America was awarded what's called statutory damages for copyright infringement. Prior to 1978, if somebody infringed your copyright, you were entitled to recover whatever profit you lost because of the infringement or whatever profit the infringer made, which really made it not worth the cost of filing a lawsuit. So in 78, the copyright law was changed and a provision was added for the copyright owner to recover statutory damages, which is $30,000 per infringement. And in the case where the infringer is a really bad guy, you can get that trebled. So we had grandma up in Wisconsin. Grandkids downloaded some music. They went after her for 10 songs, and the damage award was $1 million. So, yeah, very powerful. And in addition to things like labels, your advertising copy, your graphics, whether they be in literature or brochures, the brochures themselves, owner manuals and whatnot, all subject to copyright protection. Sometimes we think of copyright more in connection with music or film or art, but it has a very important application in the business world. The last flavor of intellectual property, and I do mean flavor, is a trade secret. And so KFC claims that the combination of 11 herbs and spices is a trade secret. I don't know about that. I think Abby in her lab at NCIS could probably figure out what is in that blend of spices and herbs. Trade secret in that case may involve the way it's processed and marinated and the timing and everything. But trade secret's basically information that is known to you exclusively or pretty much exclusively, information that is not generally known, and it's its own kind of protection because it's not generally known. You protect it by keeping it secret. The term of trade secret protection is completely up in the air because once the information gets out, the trade secret is gone. Trade secret could last decades. Coca-Cola claims that the Coca-Cola formula is a trade secret, and they've been making Coca-Cola for 100 years, maybe. I neglected to mention the term of copyright protection. For a work produced by an employee of a company, the term of copyright protection is 120 years from the date of publication. Pretty much going to outlive the useful life of any graphics or owner manuals, but you really don't have to worry about your copyright expiring. Yeah?
Detail a little bit more about when you transfer something that's electronic media form, it may not necessarily copyright. What is does it automatically create a copyright in terms of if you're the original author, independently from working for a company?
Yeah, that's an important point because the ownership of copyright is determined at the time the work is created. If a copyrighted work is created by an employee within the scope of his or her duties to the employer owns the copyright. That's a work made for hire, and ownership of the copyright automatically vests in the employer. An individual who is not an employee who creates a copyrighted work owns the copyright in that work, and that copyright can only be transferred in a written document. A lot of people misunderstand the term work made for hire. That specifically applies to the employee whose work is automatically copyrighted and ownership vests in the employer. If I go out and hire an architect to design plans for my dream home, someday, I have hired him. The plans are work that he prepared because I hired him, but it is not a work made for hire. The architect prepares the plans, owns the copyright in them, and what I've bought is the right to use those plans to build a house. I can only wind up owning the copyright in those plans if I get a written assignment from the architect. Is that helpful? It goes beyond that.
Yeah, you can take that in a lot of different directions. If I'm developing a customized program for a particular company, and I'm independent, it's my design.
It's exactly your design.
And they don't own it, even though they paid to do it.
Yep.
They have no ownership rights.
Not to the copyright, but obviously they're going to have a right to use it.
Right.
But you're going to have the right to take it somewhere else. And this is a real pitfall for companies that hire work out. You hire a web designer, copyright extends to website design. Who's going to own the copyright in that? Well, the website designer, unless you make an agreement in writing. You hire a graphic arts firm, and they put together your labels or your product graphics. That company is going to own those copyrights unless you make other arrangements. Of course, if that company hires independent contractors, you're going to have to go through two transfers. Okay, so that's an overview of intellectual property. Let's look at it from national and international perspectives here. So patents are creatures of national law. Each country has, well, not every, countries have their own patent laws. Countries issue their own patents. There is no international patent. So if you want to protect an invention, you're going to have to go to every country where you want that invention protected. If you're a U.S., if you reside in the U.S., you start in the United States. The application is prepared and filed in the United States Patent and Trademark Office. Filing dates are very important because, as I mentioned earlier, whether your invention is entitled to a patent or not depends on what came before. And what came before is measured from the day you file your patent application. If you wait a month, there's going to be another month's worth of stuff behind you. So filing date is very important. But if you file a United States patent application tomorrow, Monday, and you want to protect that in 10 countries, in addition to the United States, what an expense and burden it would be to file those 10 applications the same day you filed your U.S. application. Good news. We have treaty partners that have agreed that a patent application filed in, let's say, Europe, that is based on a United States patent application will be treated in Europe as if it was filed on the day that it was filed in the U.S. if the application is filed in Europe within 1 year of the U.S. filing date. It's called a right of priority, and if you go outside the U.S. based on your U.S. application and you do it within 1 year, automatically, magically treated as if it was filed there the day you filed in the U.S. A year is a really important period of time. It's almost enough time to figure out, do I want to keep throwing money at a chance to protect something with a patent? Expensive in the U.S., expensive outside the U.S. Yeah, Chris?
You see a patent pending on things. Is that the kind of protections that
Having a patent application pending in a patent office gives you no right against somebody that copies your invention. I think it does have some value, and I think the value comes from uncertainty. And the uncertainty comes around because somebody who's looking at your product and says, I'd like to start making and selling that. Well, if you have a patent pending, that would-be competitor won't know if you're going to get a patent, when you're going to get a patent, and so investing in going into competition with you has some risk because you might be able to stop them at some point. And I think we all know it's very expensive to bring a product to market. So patent pending, yeah. And until the day the patent issues, and we figure out where the fence is around that particular invention, it is a guessing game. You just don't know. And a fellow my dad worked with for decades always said, and I think there's some truth to it, a pending patent application is worth more than an issued patent because, again, once it issues, you know where that fence is and you can design around it. And that's perfectly legal, and we encourage that. The idea of the patent system is to encourage invention and innovation by making a reward available, the right to stop other people. A lot of hoops to jump through to get that right, though. So, okay, so we've got that 1 year right of priority, and very important, but we do have what's called an international patent application. So, no international patent, but using the international patent application system, and that's part of the provisions in what's called the Patent Cooperation Treaty, and lawyers love acronyms, so we call it PCT. You can start with your U.S. application, and within 1 year, you can file this international patent application and postpone by another 18 months the need to go into individual countries, and you still retain the right of priority back to your U.S. filing date. So you have 1 year from the U.S. filing date if you go directly into another country and file. You have 30 months from your filing date in the U.S. if you go into individual countries via the international patent application process.
In that process, though, it's a one-shot deal to identify those countries on the front end.
Good point. Good point. And your filing fee to the PCT, the international application, can be filed in the U.S. Treaty partners under PCT, approximately 100. Probably would have been a good thing to check before I got up here. In that application, you have to designate the countries or the regions. You can designate the European Patent Office and cover a lot of countries with one application. You can't come back and elect a country that you haven't designated initially. All right.
David, the reverse through, if I designate a lot of countries, must that then follow through and apply for patent protection in all the countries I designate? Or
You can bail. You can bail at any time.
the thing to do is go in with everything at the start and then pick and choose what you really want later on.
Yeah, unless you really have a crystal ball and you know what's going to happen. And, of course, once you file in a foreign country, you can bail at any time. And same's true in the U.S., obviously. Okay, so I've already whined about enforcing patents in the United States. Imagine being in the U.S. and trying to enforce your patent against an infringer in a foreign country. Oh, really? Okay, well, let me back up. Behind the, well, starting on page 14, I have an example of a patent that issued in Canada, and it issued to Wheelboy, as you can see by page 15. That Canadian patent issued on a Canadian patent application filed within 1 year of the U.S. filing date for Rolf's wheel patent application. So we used the right of priority there and issued that patent. But he had a year to think about it before he had to commit to the cost of going into Canada. And then on page 16, we have the front page of an international patent application. And it's important to point out here that patent applications are published 18 months from the filing date. So 18 months out, there's no secret left, there's no mystery about what your invention is, but the mystery remains as to what the final fence is going to look like, because you can adjust the scope of protection that you're seeking. Actually, some people look at a patent and they look at the drawing and they say that's a patented invention, but actually it's more complicated than that, surprise, surprise. You have to define in words in something called a claim what the patented invention is. So we don't know what those claims will look like. I think of a claim like a recipe. You've got the ingredients or the elements that make up the invention and how they go together, and there's a definition of the patented invention. It has to define something that's new and unobvious from what came before, and yet you want it to be the least restrictive as possible so that your fence is as big as possible. Okay, enforcing. Oh, okay, no, we've got the colorful one. Page 17, we have the cover of a European design registration. That actually covered 3 pages, and it corresponds with the ornamental design for the battery case that we saw in a U.S. design patent. Okay, confession. The U.S. system for protecting ornamental designs of a product, for lack of a better term, sucks, because you're looking at $3,000 to $5,000 to protect a design with a U.S. design patent. Europe, they got a good system because you can file an application to register your design in Europe. You can file a single application in Europe to register 100 designs, variations on a theme. And that's a good system. The U.S. is wrestling with the idea of adopting something similar, and it couldn't come soon enough, I don't think, because really that's a fundamental, important right. You make a good-looking product, you don't want that copied identically. A lot of time and effort, creativity goes into the final design of a product. Okay, now we're enforcing patents. And we're talking about patents outside of the U.S., and all patents are not created equal. The value of the patent is going to depend in part on the laws of the country where the patent issued. The Small Business Administration, in cooperation with the government, the GAO, General Accounting Office, I always trip over that. On page 22, we see what's actually an 11-year-old ranking of countries in terms of the value of a patent in that country. And the top tier, the tier A countries, is a short list. There are 5 countries. The U.S. is in there, United Kingdom, Netherlands, Canada, and Australia. So somebody, actually there was quite a, take drugs, okay. Not so good countries, B tier countries, still got some value there. Then you got your tier C countries. That's a big list. Patents not worth so much there. And that's compared to the U.S., where if you have to enforce your patent, you're going to pay everything to your patent attorney that you have a chance to recover. So that kind of sucks. Last year, the Patent and Trademark Office put together the material starting on page 23 about international patent protections for small businesses. It's a 70-some page report. Sir?
I was recommending you uncross your arms because you're covering up your microphone.
Nobody wants to hear what I'm saying. Come on. The Patent and Trademark Office, we've got the executive summary here, and they say, oh, patents in foreign countries are good for U.S. businesses. Okay. All right. I think that's overly broad and not universally true. On page 27, I've reproduced an article. No, I didn't ask permission. I'm sure it is protected by copyright. But there's an exception, the fair use exception for face-to-face teaching activities, so I'm sure I'm all right that way. Article by Leonid Kravitz. I share his view, and his view is for a U.S. company, getting a U.S. patent has some value. Throwing money into getting foreign patents, really not a good cost-benefit situation. Okay. Trademarks around the world. Very important difference between the United States trademark system and trademark systems in every foreign country. In the United States, the right to register your trademark is contingent upon using that trademark, meaning you have to put the trademark on a product or use it with a service before you can complete the registration process in the United States. We call it a use-based system. And up until 1991, you could not apply to register your trademark in the United States until you had used it. And the system got turned completely upside down. We had people putting a prototype into a box and handwriting the trademark on it and sending it to Aunt Sally in Minnesota. You have to use the mark, and for the federal registration system, you have to use it in commerce that can be regulated by Congress, and one example of that is interstate commerce. So yeah, I've used the mark. I sent a product with the mark on it across state lines, but that's not what we're really talking about in using a trademark. So in '91, first time in the U.S., you could apply to register your trademark before you had used it. You could file based on your intention to use it. You still can't complete the registration process until you begin using it and then submit a statement to that effect to the Patent and Trademark Office. This system has some benefits. People can't just go out and glom onto a bunch of trademarks that they have no intention of using with the idea that someday they'll have some value to somebody else and then they're going to sell that. We didn't want to create a trademark industry of selling trademarks. Foreign countries, they don't really care. You apply to register your mark, the mark gets registered. You haven't used it, doesn't matter. You own the rights to that trademark. And this presents a huge dilemma for U.S. companies. There be pirates out there. On page 30 is the beginning of a blurb from a 1928 book. And after my father died, quite some time after my father died, we found a banker's box labeled miscellaneous junk from JCP drawer, John C. Purdue. And among the items in the box was a book. It was about this thick, smaller than a regular book. And it was a publication from a law firm in New York for its clients. And again, 1928, information about protecting copyrights and trademarks around the world. It was a fold-out map, which, not surprisingly, looks different than a world map we would see today. So we have the copyright section and the trademark section, and the trademark section begins with general remarks on foreign trademarks, and you don't have to read very far to see warnings about trademark pirates. But I can't find it. Piracy, yeah, 31, the bottom. Piracy is a particularly serious condition in countries such as the Argentine. Yeah, but the real piracy comes when somebody familiar with your business in the U.S. and familiar with your trademark beats you to a trademark office in another country and registers your trademark there and thereby gains the right to control your use of your mark somewhere outside the U.S. I know this is a big problem. I worked with 2 clients, and before I started working with them, they had shipped product to Europe to a distributor, and the distributor bought the, well, the distributor turned around and registered those clients' trademarks in Europe. That's a problem. In one case, the U.S. company spent upwards of $100,000 in court and actually gained the right to the trademark and got it assigned back to it. What a waste of money. Couple $1,000 application could have been filed to register that mark in the owner's name in Europe, and that would have ended the deal. Another client, he had a customer in Europe. And it was kind of like distribution, but what was really happening was the guy in Europe bought the batteries. Yeah, it's the batteries with the cooling fin. And the kinetic mark is the mark on the batteries. And the guy that was buying them from my guy turned around and registered kinetic in his own name in Europe. And talked to 3 different law firms, and my client convinced itself, I don't want to roll the dice and spend $100,000 and maybe not get my trademark back. In that case, he decided it was more economical to adopt a different trademark for his sales in Europe. But that's not good. You don't want to do that. We don't have international patents, but we do have international trademark registrations. And U.S. was Johnny-come-lately in the international trademark system. It is operated under the auspices of the Madrid Treaty and the Madrid Protocol, and I think I've done 7 or 8. I can take a client's mark. Let me back up. Just like with patents, you start with your home country. So you have to start in the U.S. with an application for U.S. registration of your trademark. Then on the basis of that, you can file an application for international registration, and it is tied back to your U.S. application or registration, and it gets filed electronically in the United States Patent and Trademark Office, and it goes to Geneva, to the World Intellectual Property Organization. And at the time of filing your international application, you designate countries where you would like to protect the trademark. And we have 87 signatories. Mexico joined up in February. Canada has stubbornly refused to sign on to the Madrid Protocol. Europe is in it. You can designate Europe as a region, and several European countries individually have ratified it. This is a good system, and unlike the international patent application, in an international trademark application and in an international trademark registration, you have designated certain countries, and at any point in time you can add countries. You can subsequently request extension of protection to member countries. Yes, sir.
How come a country like Canada doesn't want to get involved?
I have no idea. Now, when did you hear a lawyer say that? Huh? I don't have a clue.
Steve?
Yes, sir.
The international trademark, is that still use-based when you start in the U.S., or is it registration-based when it gets to the international?
Great question. You have to start with the U.S. and you are use-based. You can file in the U.S. based on an intent to use, and then base your international application on that. However, if your U.S. application is abandoned, which would happen if you never start using it in the U.S., or if the United States Patent and Trademark Office refuses to register your mark, your international application evaporates. So United States is really under a handicap that way. But once you get into foreign countries, you are looking at the registration being the source of the rights and not use in those countries. Oh, I had a really good point. Priority. So with the trademark side, it's 6 months instead of the year with the patent. So you can file in the U.S. and if you file an international application or an application in an individual foreign country, and you do it within 6 months from your U.S. filing date, the foreign application or the international application is treated as if it was filed the day of your U.S. filing date. And these grace periods, or these right of priorities, the 6 months and the year, are, I think, very important and very beneficial, because it gives you time to regroup and look into the crystal ball and make a good decision, hopefully. I think more is better. If you know you're going into a country, by the time you figure that out, you should have already taken steps to protect your mark there. If you're thinking about it, I mean, the cost is not high. It's nothing like a patent, and better to lay the groundwork for protecting that trademark somewhere you might go and not use it than to not lay the groundwork and wind up with somebody else owning the rights to your name. I mean, arose by any other name? Not true with trademarks. Your trademark is who you are. It's your identity in the marketplace. And you need to control that in connection with your product or your service. Yes, Sam.
How about imitation brand names? Names that are not the same but are similar in pronunciation to your brand name?
Sure.
Like, I don't know, there's the Chinese auto company that uses the brand name Chery, C-H-E-R-Y.
Kind of like Chevy?
Yeah.
Yeah.
And another one is Erke, E-R-K-E, which of course sounds similar to Nike.
Mm-hmm.
And in fact, their logo is pretty similar to Nike's also.
The swoosh.
So, yes. Is there any protection then? At some point in time, can they bring that brand name over here and use it in the United States?
Okay. Now I'm going to sound like a lawyer. It depends. And what it depends on is whether in this example, the Chinese company is using a mark on a product where that use is likely to cause confusion as to the source of the product in the United States. So we got to balance some things. We have to compare the products that the marks are used on. So they can be identical, they can be related, or they can be unrelated. Then we have to look at how similar the marks are. If they're identical, they're identical. If they're similar in sound, appearance, or meaning, that's something. And if they don't look or sound alike, yeah, no infringement typically there. So,
So this will be clarified through the court system then?
well, the courts can resolve it, or if a conflict comes up and you get into court, you're probably going to figure out some way to resolve it before you go to trial. Typically, if you have a problem with somebody else using your mark or something too close, you write a letter and start a discussion. I started one last month, but it seems to be a one-sided conversation. And then you have some really interesting fact patterns. You have parity. North Face is a trademark for outerwear for coats. And a college student thought, North Face, how about South Bud? And a lot of people were really amused by that, but not North Face, so they wound up in court. Didn't sound alike, didn't have the same meaning, was funnier than North Face, but North Face succeeded in stopping that. So, registering outside of the U.S., on page 35, we have a certificate issued by Office for Harmonization in the Internal Market, or since that's so long, OHIM, O-H-I-M. That's a certificate of registration of a trademark in Europe, and that looks like this again. On page 36, we see the data in the European trademark registration. We see the word mark, Mississippi Barbecue Sauce, Real American Barbecue National Best Taste Award. Then we see the mark including the design. And then we see the owner name, the Fremont Company. Sounds familiar.
If you haven't tried the sauce, I recommend it. It's available at Giant Eagle. Giant Eagle or Anderson.
Giant Eagle. Yeah. We looked long and hard. We got to get more distribution. And if you weren't here again early enough, Bloody Marys with a little shot of barbecue sauce. Awesome way to start the day. I don't think that would be good. So with a single application, the Fremont Company's mark is registered in approximately 40 European countries. So that's pretty awesome. And on page 37, we see they went one step further. And up at the top of page 37, we see the acronym WIPO. It's not an acronym, it's a abbreviation. World Intellectual Property Organization. Romarin is the database. You can get online and search marks registered internationally, registered in Europe, registered in China. Yeah, I don't speak Chinese. The only foreign language I studied was French, and that was high school. And bonjour! That's about it. But a lot of the foreign trademark offices have English language-based search engines. So that's pretty cool. Am I supposed to have finished a few minutes ago? Actually, we don't have a whole lot left. So in the international registration, as we said, you're going to have to pick out countries, and you can do that. You have to do it initially, and then you can expand that at a later point in time. So, have to flip over to page 38, and the second to last line, designations under the Madrid Protocol. We have Russia and the Ukraine. Why would somebody register a trademark in the Ukraine? Because they're going to ship there, because they've got an order. But they laid the groundwork, and they reserved the right to the mark. And nobody in the Ukraine can get in ahead of them. Hats off. Well, Matt, you're the only one with a hat. Tip of the hat from Matt. Right of priority. Yeah, not a lot of slides, but a lot to cover. Trademark enforcement globally. In the U.S. and foreign countries, enforcing your trademark is pretty good value, especially compared to enforcing a patent against infringement. However, if you wind up in the situation where a couple of my clients did, and you don't own your trademark and you want to claw it back, yeah, you're rolling the dice and you're spending a lot of money at the table to roll them. Yes, sir.
If we did the right thing and registered and did all that stuff, and someone still tries to do something similar, ballpark what cost-wise to fight it? I mean, you mentioned $100,000 before. Is that?
That's to get your mark back.
That's to get it back.
Yeah.
Somebody fight them off.
I have not been involved directly in enforcing a trademark outside the U.S., and I know something about international intellectual property, but of course if I represent a client in the U.S. having a problem in Europe or the Ukraine, I'm blessed with a network of lawyers in lots of foreign countries that I turn to for advice. And again, it can play out, at one end of the spectrum, you write a letter and maybe it was innocent. And they say, oops, my bad, and they change. And if you go to the mat and you wind up in court, 50, 100, 200,000. Trademark infringement damages, kind of hard to get in the U.S. unless it's egregious, and It was an obvious case where the infringer was trying to benefit from the goodwill of the trademark owner and make sales that he wouldn't have otherwise made by the trademark infringement. You're not going to recover damages for an innocent mistake. The remedy against the trademark infringer is primarily an order, an injunction prohibiting the further use of that confusingly similar mark. Foreign countries, generally speaking, damages are more readily available. And then you have the European-based system of law, which says, if I sue you and I win, you pay my attorneys. They have less lawsuits than we have in the U.S. per capita. Frivolous is not a, yes, Trish?
How much, when you get into situations like this, how much does individual country law come into play? Like, what if each country has its own laws regarding, how does that affect?
Hugely.
Yeah.
Hugely.
So you would need to, I mean,
You need
not
local.
just one-sided, you would need to be well versed on what their policy is.
Yeah. Yeah. Or you need to know a guy. Or you need to know a gal. Yeah. So yeah,
So that would just even add more to the, not only the cost, but the confusion and so you just have to say to yourself, is it really worth it?
exactly right. And if it's damaging your business, that's one thing. And if you're still making sales and it's not hurting you, yeah. Yes, Frank.
It might depend on who's knocking the door, too.
That's true too.
Yeah, yeah.
Yes, Blaine.
Well, if you go a step farther, if you have an aspiring company in the Ukraine who decides to put out Alabama barbecue sauce.
Nice. I was going to say Mississippi.
Well, no, because just use that for example. You just grab another state's name,
Mhm.
put on it, this would be my company out right there. Because it's technically a state.
No comment. Well, I don't know what the trademark law in the Ukraine is.
I don't know.
And but I do have some materials about enforcing trademarks in various countries around the world. And oh, yeah. See, I was a page behind y'all. No. Oh. Okay. I do have them. However, to get to them, we're going to talk about global copyright law for about 2 minutes. Also governed by treaties, and we have treaty partners around the world, and we've signed the Berne Convention, we've signed the TRIPS Amendment, and basically rights owned by a U.S. company and do register your copyright because it's so inexpensive and the term is so long. Those rights will be recognized more or less in countries that are treaty partners. And yeah, good stuff. Berne Convention, U.S. copyright. And they're typically you don't, in virtually every case, you don't have to do something within 6 months or within 1 year in a foreign country. If you run into an infringement in a foreign country, you can claim rights based on your U.S. registration. You may have to register your mark in that country at that point to enforce it, but a lot less hoopla and hoops to jump through that way. All right. Sorry, I was one slide behind. Oh, and one more hurdle to get to international trademark enforcement. Trade secret protection. So in the U.S. we have these trade secrets, things that are not generally known, that give you an advantage in the marketplace, a competitive advantage, like the secret barbecue sauce recipe. I understand that the recipe has been cut in half and one half is in one safe and only one person knows the combination. No, that's Coca-Cola. Okay. And trade secret is a lot of smoke and mirrors, really. Again, Abby Shuto, the forensic scientist at NCIS, with her mass spec, she could probably figure out what's in it.
So to have a trade secret, you have to list out what it is and actually publish it?
Just the opposite. Just the opposite. And it's so murky, you know, what is the trade secret? And so it has to be not generally known. Has to be secret. It has the word secret right in the name of the protection. And you don't have to register it anywhere. And nobody really knows what it is. And as long as you keep the secret, you have a chance at stopping somebody else who acquired it wrongly, like a former employee who leaves. Trade secret protection is subject to the need to take steps to keep it a secret. So if you have employees and they know half of the recipe, you want to have an employee agreement that says, look, we have trade secrets, you're going to learn them. When you leave here, they're still ours, you can't use them.
So it would have to maybe come out
To enforce it, and then you get into all these procedures where things are filed under secrecy orders and yada yada.
So is this assumed or is this contractually or is?
No, it's you can protect it contractually. You can help yourself. You can take steps to keep it a secret with contracts. Sure. I mean, at some point, if somebody has acquired it wrongly and is using it, and you have to stop them, you're going to have to define what it is, what the trade secret is. There was a trade secret case involving guys that left Johns Manville, the fiberglass company. They set up Guardian Glass and started making fiberglass, and Manville said, you're infringing our patents, you're using our trade secrets without permission. And one of the trade secrets that was claimed was using water to cool a trough through which molten glass flowed. So apparently water cooling is a secret? Probably not. Probably not. But it's know-how. It's things that you know how to do that other people don't know. It used to be customer lists. Somebody could walk out the door with your customer list and really do some damage. But the internet changed that because potential customers aren't hard to find anymore, even if you don't have a list. Absolutely. Employment contracts are huge, and also contracts with independent contractors. Yeah. Contracts are extremely important. I mean, if you're going to sell a product into Europe, whether you've taken the step to protect your trademark there or done any patent protection you want to do, you're going to have an agreement with the buyer, and that agreement should address intellectual property. This is mine. This is what it is. This is mine. You don't own it. You can't use it without my permission. It's just another layer of protection. Okay. We are on the last slide. Intellectual property index. We got some more tiers of countries. Page 42 starts some materials blatantly copied from Taylor and Wessig, and this is their third GIPA, GIPI, Global Intellectual Property Index. So on page 42, we have 5 tiers. Tier 1. All the good. I'm sorry, because these are color coded and very lightly color coded. I can't tell where tier 1 ends and tier 2 stops. The only one in a lower position than China is India. And you're talking about huge markets. So this is overall with intellectual property. And then on page 43, we have a progression of rankings, GIPA 3 compared to GIPA 2, And then page 44, we've broken it down. Oh, wow. I apologize. GIPA, the second column on 44 is the trademark index, and then the copyright index, and then the patents index, and then the design index. Designs get pulled out separately from patents here. And then this intrigued me, the personal data index, which not so much intellectual property, but more identity theft kind of stuff. How well is data protected? So again, it varies country by country, Trish. That's exactly the point. And nobody in the U.S. can be an expert on what it is in another country. Got to know people.
But then right before the country's laws, then on top of that, if you're a member of one of the trade pacts, so that would affect it. So like you've got all these different, between the policy and the law,
Mm-hmm.
and international governmental agreements, you really have a lot in there to juggle if you do have a case. So what applies, what supersedes something else, right?
Yeah, it is. It's mind-boggling.
Yeah.
You need good advisors who understand
And
enough.
therein lies the cost, because each one of those tiers adds an additional cost to whatever it is you're trying to fix.
But there are good advisors and there are good attorneys that will give you a straight answer.
But a small company versus a Procter & Gamble, who's got a bank of lawyers on call all the time.
Well, I know an attorney, a trademark attorney at Procter & Gamble. Actually, he retired and now he makes more money. Procter & Gamble, generally speaking. Well, my point is, generally speaking, an ethical company. And they want to adopt marks that they can establish rights in. If you come across a scoundrel and they're really acting like a scoundrel, a court should make quick work of putting a stop to it.
Well, we see this a lot. I mean, with our stuff, it's commodity. It's, some stuff is so, but we see it in China a lot. China will take our little 30-ounce dispenser. All of a sudden, it shows up a copy shows up all over the world.
Mm-hmm.
And, how do you fight that? I mean, we find it eventually goes away because the quality's not there, but,
Which is huge. I mean,
yeah.
the value of your trademark directly proportional to the quality of your product. And if somebody masquerading as you and putting out a lousy product, that really hurts.
It's just too hard to do it, and it's very costly for us. It's a very costly thing, and do you take, that dispenser cost is maybe $3, and China's making it for $1.
Mm-hmm.
What we find is that people will call us and say, oh, I found this exact same one in the market. They go to use it.
Spring.
5-6 years, yeah, it takes care of itself, because in a year, in 6 months, the China one is, pretty much broken down.
Mm-hmm.
But they are very good at copying, and that's one thing you gotta, you have to address.
Well, sometimes clients come to me and they say, I want to protect my intellectual property. And I say, where do you want to protect it? And they're U.S. companies with no thoughts of going outside the U.S. And they say, well, in the U.S. and China. Why do you want to protect it in China? Well, I don't want them to knock off my product and bring it in. Well, U.S. intellectual property law extends to the border. And customs and border protection will actually, that's not what they call it now. Customs and border? Okay. They will help intellectual property owners. They will seize goods. They will detain those goods. They will give the importer or exporter opportunity to be heard. And if a convincing case isn't made, the property can be detained and after 30 days seized and destroyed. So U.S. intellectual property law can be used to deal with activities in foreign countries where those activities wind up having an effect in the U.S. Is this okay, Matt? Down? Okay. Thank you. Questions? We did that. Yes?
What are the benefits of a provisional patent?
Well, that is a filing date. So you stop stuff that came before from accruing, and that has a 1-year period. It has a 1-year lifespan. Thanks for bringing this up, because it's a really good mechanism in the U.S. Filing a regular utility patent application, $5,000 to $10,000 typically. There is a system called a provisional patent application system in the U.S. You can file a provisional patent application describing your invention and how to make it. You don't have to write a claim and try to define the patent protection that you might eventually want to get. You don't have to have formal patent drawings that look good like the design drawings in the bottle design patent application. And it doesn't have to be perfect grammar or spelling. That application gives you the filing date and 1 year to decide whether you want to go forward. It is a priority date. You can claim a right of priority in the U.S. and foreign countries based on your provisional. You have that 1 year period of time, and since you probably have an unpolished provisional application, you have a year to get it in shape, and you have a year's worth of learning about the invention and what is important about it and what's not so important about it. You also have a year to figure out, well, it was a great idea, but it'll never work. It doesn't fit our business model. It's too expensive, what have you. So the provisional patent application system in the U.S. goes back to, was it 95 or 2001? I don't know. I'm running out of words up here. But
When an application gets published, the provisional stays in the basement.
provisional never gets published, it never gets examined, and no patent can issue on it. And you do have patent pending, and you can put patent pending on your product. And you create that uncertainty in would-be competitors. Well, you know, what's he got? Playing it close to the vest, I don't know. Do I want to invest in this and be subject to having to stop, or?
You mentioned patent pending, I'm sorry. Is that something that's issued or something I can claim? Some legitimacy?
Patent pending is a
Somebody just rubber stamp everything they do.
patent pending where they didn't have a patent application pending.
Can I call them out?
There, you can call them out on it. In fact, there is a false marking provision in the U.S. patent law, and there are remedies available to someone who is damaged by someone else falsely marking a product patent pending. Also marking a product with a patent number or an expired patent number. So you can't do it. You can do it. If you do it and you don't have a patent application pending, you're subject to penalties. Thank you. Yes, sir. Well, the filing fee to the Patent and Trademark Office is $125. About half the people that I deal with that have a patent application pending that's a provisional patent application have done it themselves. There's a form on the Patent and Trademark Office which transmits a provisional patent application, and whatever you want to put together and call a provisional patent application can be mailed off, and then you have patent pending. It doesn't have to teach how to make and use your invention. You can get the right to put patent pending on something for a couple $100. Whether that has any chance of maturing into a patent with any value, it doesn't matter. But before you go to the next level and file your utility application, your regular application, invest $5,000 or $10,000 in it, you have patent pending. And you have a date that you can claim the right of priority. So,
So is the timeline that, or status would be through provisional, then a patent pending, and then a patent, or does provisional go right to a patent when you put the application in? Is provisional the first step?
you can start with a regular application, get your filing date, have your 1-year priority, right?
That's a lot of money, right? So the easier.
To start, yeah, a regular application prepared by a patent attorney. Yeah, we're weird, we talk funny, and we try to figure out, you know, here's the invention. Guy walks in with a wheel. I want to get a patent on this. And the patent attorney has to figure out, well, this is an example of this, really, and what really is the scope of protection we could carve out. And yeah, it's nuanced. I couldn't write a good patent application on a chemical composition. It really helps to know that. When I enter into a relationship with a client, I know nothing about the technology. I've studied engineering. I have enough knowledge to be dangerous, but also enough knowledge to be a good student. And just like I have to be a student on the technology, I expect clients to be good students on patent law. I don't want to tell them what to do. I want them to understand what the options are and make their own decision. So, yes, sir.
When you go to file a provisional patent, do you actually have to conduct the research to make sure that your idea is actually an already patented idea? You know, say you come up with some.
Have to? No. Ought to? Sure. The cost of a good search and opinion is neighborhood of $1,000. So compared to $10,000, if you really think you want to get a patent, don't invest $10,000 without doing due diligence. Do the patent search. And you can do your own online. U.S. Patent and Trademark Office has a database with every word of every U.S. patent back to 1976. And you can just hunt and peck and put in keywords that would relate to that and come up with some patents. Or you can hire a professional. So, yeah.
Patent law just changed here a month or two ago.
Less than you would think, based on all the hoopla. Thumbnail. We were the only country up until March that had a system of patent law where if two people try to get a patent on the same invention, we would look at when they filed their applications, but we would look deeper than that and we would say, well, he filed after the other guy, but he came up with the invention, conceived of it, before the other guy. So we're going to give it to the guy who filed second. And now, like every other country in the world, the U.S. has gone to what's called first to file. So it is just a race to the Patent and Trademark Office, which is going to give more patent attorneys more gray hair and less hair. Because once the client says, I want to file, any delay could be bad for the inventor.
Now, is that where you would probably do a provisional just to lock it up and then start the actual application?
Absolutely, because you can knock out a provisional pretty quickly and for a much lower cost. And you have a year to think about it and to improve it. Because your regular utility application will be based on your provisional, but you can enhance that, enlarge it, take it in a different direction.
Thank you.
Thank you.
We'll be hanging around if there's any other questions, right, for the rest of the
Oh, I got nowhere to go.
Okay, about a 15-minute break.
Hanya. Turned red. Thank you, Paul. Hanya, it turned red.
Oh, you turned red? No
Yeah.
charge. It's fine. No, it's not off.
Oh, it's good.
Yeah.